Hi, it's Mike DelSignore, Massachusetts OUI lawyer. In today's video, I want to talk about what happens if you're charged with a second offense. The case is going to be heard in Quincy District Court. Quincy District Court, big courthouse. Your arraignment is going to be on the first floor upstairs. They do the pre-trials. First court date, you're going to enter a not guilty plea, get a further date. On a second offense, typically you'll be released on your promise to appear, personal recognizance. If your first offense is close together, there could be a condition of alcohol-free testing, or if you defaulted, you might have to post a small cash bail. But most people, second offense, going to be released on their promise to appear in court. Now, second offenses, you have basically two categories of them. One, your prior offense is outside of 10 years. In that case, if you admit to the charge or if you were found guilty, potentially, and it's easy to do this on a plea, you can get what they call the second chance first offender, where you can get essentially a first offense resolution of the case, lose your license only for 45 days instead of 2 years, and be able to get back on the road with an interlock device. This can have a major impact if you refuse a breath test and the case is not winnable. You'd have a hardship for 3 years plus 45 days and the interlock for 5 years. So it allows you to get back on the road much quicker. Let's say the two OUIs are within 10 years. If you refused a breath test, you're not driving for 3 years unless you win that OUI charge and get the judge to allow a motion to reinstate your license. Theoretically, there's an appeal to the RMV to challenge the refusals. Those are very unlikely to be successful. So practically speaking, two OUIs inside of 10 years and there's a refusal, you got to win the case if you're going to drive prior to 3 years. If you plea out, you're also looking at an additional 2 years after the 3 years. So realistically, you're not going to get back on the road for 3.5 to 4 years. And of course, you'll always have an interlock device. So these cases on a second offense can have some major implications for when you drive. But still, a judge or jury is not supposed to consider you had a prior offense. So you might want to consider fighting the case. There's a vast difference between being arrested for an OUI and being convicted. It's easy to get arrested if the officer smells alcohol, they make some observations, they're probably going to arrest you. But to be convicted, they're going to prove the case to the highest degree of certainty, an abiding conviction to a near moral certainty. And it could be you resolved the first case, maybe you should have fought that one. Maybe you didn't have a lawyer that did a lot of OUI cases. So think about it when you consider this case. Make sure that you explore the opportunity of fighting the case. You know your defenses. You're with an attorney that knows the court, because there's some variations in how courts handle OUI charges. For the most part, there's a lot of similarities, but each court has its own little quirks that you should know about. I've been doing this for 20 years. I know the little nuances of every court, especially Quincy District Court, and can help you make the best decision for yourself and for the case. Now, sometimes people say, should I get treatment? Absolutely. If you're arrested for an OUI, it's the second time, something went wrong. It might be that I can get you out of it. It might be you'll be found not guilty, but you probably do need some alcohol treatment. This will never be a negative. In other words, your treatment will never be proof that you committed an OUI offense. It's only going to be a positive. If you lose or try to work out a resolution, you tell the judge, they'll be happy to hear it. So it's never considered an admission of wrongdoing. Very common misunderstanding people have that, hey, if I start getting treatment, they're going to think I did something wrong. No, if you're in court, they think something has already happened, something wrong's happened, that you have some problem. Whether it's a criminal issue or something the government can prove is one thing, but the judges, DAs always want to see people help themselves in court. So if you have an OUI charge, keep in mind the field sobriety test. A lot of reasons why somebody may not be able to perform those tests perfectly. Could be the surface, could be your medical condition, could be you did fine, but the officer didn't score it correctly. I see that a lot. On the video, sometimes we see the officers sort of interfering with your performance of the test, where the officer's doing the test while you're doing it. They stop you in the middle of the test. I've seen a lot of things that don't show up in reports, and I know from experience, sometimes I can even get this stuff out on cross-examination of the officer. So if you're charged with an OUI, let me help you. I can help you make the best decision. Certainly a second offense. I've handled a lot of these over the years. Help you get back on the road and decide how you want to handle the case to make the best decision for yourself for your family, for your future. My passion's helping people charged with OUI cases. All over Massachusetts have done a lot of work in Quincy District Court. Call, text anytime, 781-686-5924.